Hi, I am Kelly Kaplan with Lawyers Weekly. Joining me today for today's Sidebar conference is Jim Feeney. Jim Feeney is a partner based in Dykema's Detroit office. He regularly tackles high-profile, high-stakes litigation, and he's a go-to trial attorney for the world's largest companies. Thanks for joining me today, Jim.
Thanks for having me, Kelly.
All right, so we've got something exciting going on for Jim. In May, Netflix debuted a new 6-part series called Trial by Media. Each episode takes a look at a high-profile case that played out in the courtroom and in the court of public opinion. The first episode revisited the Jenny Jones show murder. It's hard to believe that it's been 25 years. So Jim, can you share a little bit of background about that case?
Sure, just very briefly, 3 individuals from Michigan went on a taping of the Jenny Jones show, which was done in Chicago in March of 1995. 2 of them participated in a surprise whereby they agreed to bring a 3rd individual with them, a friend of theirs, who was going to be the subject of the show. The show was a secret crush show. And the idea of the show was that someone would come on television with a friend or an acquaintance, maybe they knew them, maybe they didn't, and announce that they had a secret crush on that individual. In this particular case, the format called for a gay man to reveal a secret crush on a friend of his or an acquaintance, someone that they had just recently gotten to know in this case, without really knowing whether the individual shared that attention or affection for the individual. So it was a secret crush show, gay man identifying a crush on an individual who was, as far as anyone knew, heterosexual. The show was contacted by the individuals. They then reached out to the individual named Jonathan Schmitz. They invited him to come on the show. They told him it would be a surprise. They told him that they would not tell him who the secret admirer was. All 3 of them went to Chicago at the show's expense. They spent the night in a hotel, came on the show the next day. On the show, Scott Amateur revealed the secret crush that he had on Jonathan Schmitz. Schmitz reacted as sort of somewhat confused and perplexed. He said, "I want you to know I'm straight." People laughed, the audience applauded, and that was it. It was taped for airing sometime later that month. On the Jenny Jones show. 4 days later, Jonathan Schmitz got up, went to a local hardware store, bought a shotgun, having withdrawn $325 from his ATM account, bought shells, went to Scott's home in Walled Lake, and after an initial encounter, went back to his car, pulled the shotgun out, went back up to the house, and pumped 2 rounds into Scott Amateur. And Scott Amateur's family sued ultimately the Jenny Jones show, claiming the Jenny Jones show was responsible for the murder. That's it in a nutshell.
Okay. So for that matter, you were lead defense trial counsel and
Yes.
appellate counsel in the case.
That is correct.
Okay. How did your involvement in this matter come about?
I actually became involved after the case had been fully discovered and was scheduled for trial. There was a continuance for the trial for a couple months after I became involved. But so the case was all done, the discovery had all been taken, the depositions had all been taken, and I was literally hired for the purpose of trying the case. And I was interviewed. There were several people that were interviewed as a result of that. And so I went through a process with Warner Brothers in which they contacted me and asked me about whether or not I was interested in undertaking this responsibility. You know, it wasn't a big surprise to me in the sense that I had tried many cases at that point on a late assignment basis. I'd come in and sometimes called parachuting in and tried a case. So that in and of itself was not all that interesting, all that unusual. What was interesting here was the whole media aspect to it.
Okay, so that must have just been rather intense media scrutiny. I'm trying to remember TV back in the 90s when they used to have basically the wall-to-wall court TV. Was it that type of situation?
It was, and in fact, that was part of the interview process, Kelly. The folks from Warner Brothers told me that the show was very likely to be televised on Court TV, and at the time, Court TV was a known quantity. I mean, people knew about Court TV. The O.J. Simpson case was tried, was presented by Court TV. There were other civil cases that had been tried. It was a fairly new phenomenon, but it was something that had certainly been around. I was told that there would be Court TV gavel-to-gavel coverage. I was told that that there was an expectation that I would actively participate in meeting with the media, engaged in maybe up to 2 interviews a day, one at noon and one after the court was over at 4 o'clock in the afternoon. And in addition to that, there would undoubtedly be requests from the media throughout the trial for interviews, and that would be decided on a case-by-case basis. But it was absolutely understood at the outset that I would be participating and engaging with the media. And frankly, they wanted to know if I was comfortable with that, because if I wasn't, they were going to move on and find somebody that was.
So you're no stranger to high stakes litigation. I mean, that's been your career. So did you learn anything new in dealing with like this intense media involvement and scrutiny?
I did, actually. There were quite a few things. I mean, first of all, this was like no other process that I had ever been involved in. I had tried cases before where parts of trials had been televised, recorded and televised, but the idea that a case was going to be tried and covered gavel to gavel, that there would literally be a broadcast booth and an anchor desk where people were commenting on what was going on, that was something that was brand new to me. And then on top of that, to be involved in making yourself available for interviewing, in which, for example, at the noon recess, I would appear for an interview in the tent, which was set up out in front of Oakland County Circuit Court, and be asked questions about what had happened that morning and what was going to happen that afternoon. That was brand new. I mean, I had never done anything quite like that. That's for sure. And it raised a whole set of issues and interesting aspects to the representation, to say the least.
So it's almost like it was handled like a sporting event. It's like, here's the first quarter, here's the second quarter, now we're at halftime, and going, into the tunnel is Jim Feeney. So what are your comments? So,
right. Actually, I'm for people that are watching this that are as old as I am, they might remember there was an old television show called The Verdict Is Yours. And in fact, Jim McKay, the famous ABC broadcaster, was actually the announcer on that show. And the format for Court TV and their coverage of a show was very similar to The Verdict Is Yours TV show. I mean, they would have a commentator, they would have interviews, they would present. That was all obviously staged, but the way that was done was very similar to that show.
Gotcha. So engaging with the media in not only just a high profile situation like this, but I'm sure you must have throughout your career developed a list of, do's and don'ts. Here's what you should do when talking with the media. Here's what you probably shouldn't be doing. Can you share like some pro tips? What should you be doing? What should attorneys be doing when they're dealing with the media?
Right. So let's talk about the do's for a minute, because
Sure.
the do's are probably, they're very important. Number one, you have to understand the ground rules. You have to understand what the media in this, whether it's a reporter, whether it's TV, what are they seeking from you in the way of information? And are you able to provide that information? Of course you have to. This assumes that your client is willing to allow you to proceed, and there's no restriction by the court that prevents you from proceeding either before trial or during trial. Assuming that those hurdles have all been established, you need to have a message. You need to understand what your themes are. Of course you do as a lawyer trying the case, but those themes need to be shaped with the understanding that they're going to get played out in the media day after day after day. And in order to And in order to effectively engage the media, those have to be uppermost in your mind. You have to respond to questions that are asked, but you have to do it in a way, of course, that incorporates your messaging. I'm not suggesting that this is just a talking head messaging points or anything else, because you can't hide from what the evidence is. But you need to be very cognizant of the fact that particularly broadcast media is built around 10 to 15 second sound bites in a 5 o'clock news report or a noon news report or a 6 o'clock news report. And if you can't figure out how to net it out and deliver a message in 10 seconds or 15 seconds that resonates and tells your side of the story, you haven't done your job as a lawyer. So that's what you have to do. You have to figure out what the message is and be able to deliver it so that it gets past the cutting room floor and it actually makes it on to the airways.
Gotcha.
Probably the biggest thing you have to do.
So in the message, is the way to get it across better? I mean, do you want to come across as like the pit bull attorney, or what's the approach you should take?
Well, you try not to. I mean, if you're defending large corporations, which is what I've done most of my career, in many ways, you want the jury to view you as a representation or a personification of the client, of the corporation. You're representing the men and women of that corporation that were involved in whatever the event is that is the subject of the lawsuit. You want to present yourself in a way that you know the facts, you know the law, you're competent, you're professional, you don't call people names, you don't personalize every debate or argument. You try to be, you're relaxed. Sometimes you use humor to your advantage, but you're very, very focused and targeted on what you're doing. You can't come across in an interview as if you're some sort of cynical, hard-bitten defense lawyer that has no compassion, no sympathy, no understanding for any of the pathos and the turmoil that the plaintiffs have gone through to get to this point. And that's a point that you have to make repeatedly and remind yourself of that. This is their lawsuit, this is your lawsuit, and you have to be very respectful and empathetic in everything you do in front of the media, and they are always watching, I have learned, particularly in a trial that is being broadcast. They are always watching you. They're watching you leave the courtroom. They may have mics that can pick up what you're saying as you leave the courtroom. You have no expectation of privacy when you're walking down the hallway of a courtroom. So you really, really need to be very, very cognizant of who you are and who you're representing. And you can never, ever afford to put yourself in a position where you're seen as the bad guy, as someone that is evil in sort of modern parlance.
Gotcha. So keep it short, the message clear, be human, put a human face on it, and beware the hot mic.
Right.
All right. So when you're trying to present yourself in this way, say you have an opponent who's taking more of a badgering approach, how do you handle opposing counsel or even the media who is coming at you, pretty hard?
Well, that's a very good question. And of course, your training and experience has taught you over the years to know how to take a punch and counterpunch. I mean, that is really what an effective defense lawyer does throughout the course of the plaintiff's presentation of his or her case. They are constantly counterpunching and scoring points and attacking credibility, but you need to do it in a way that doesn't sound like you are aggressively. You need to do it with a velvet glove, and in the case of an aggressive, bombastic opponent who is very loud, very bullying, who sometimes acts like the classic fifth grade schoolyard bully, you have to be firm. Humor, I think, works pretty well. Sarcasm works pretty well with him when it's directed to him, because I think jurors like conflict to some extent between lawyers. They enjoy it. They appreciate the byplay. And I think as long as you keep it under control, you can get away with a lot in terms of banter and response to activities of your opponent, subject to whatever the judge lets you get away with. But you can get away with a lot, and I think you can send the message to the jury that this guy is just, maybe has a little bit too much hot air and a little less substance and a little more flair than is really required. And what does that really say about his case or her case? So those are some of the things you can do.
Okay. That's a nice transition to what you shouldn't do. What are the don'ts? We've talked about the do's for handling the media and your opponent. So what should you not be doing? What's the kiss of death, for example?
Well, I think arguing with a reporter or an interviewer is never really a good strategy. I think you can always present a response in which you appear to agree with the import of the question, but make your point in a way that is absolutely contrary to what the question, no matter how leading its nature, really is seeking from you. You get into it with a reporter, and it's never really going to end well, because they ultimately have the final say in the matter. They're the ones that can edit you out. They're the ones that can write it the way they want to write it. And there's just no percentage whatsoever in that. So that's one thing. The other thing is that a lot of times, some reporters or interviewers will ask very leading questions, and there's a tendency to, on the part of a lawyer who's, and I've seen this, answering those questions, they tend to repeat in their answer the negative statement that appears in the question, which is really a terrible idea. I mean, you should never do that. You should never reinforce for the audience what the negative import of the question was, particularly as you understood it. What you need to do is you need to have a transition like, well, that's a very interesting question, but I think it doesn't really appreciate the following, or something like that. You just move to what you want to say, but you never reinforce in the answer what you're actually doing. And the other thing that I think that you need, a lawyer should understand, and maybe they do, maybe they don't, I don't know, but there are all kinds of different levels of communication you can have with the media. And you can have this conversation with your client. You don't have to appear on camera. You don't have to appear for quote. Many times companies are more interested in getting their story factually out than they are in having you think you're a TV star and need to speak on camera. So if you can, instead of just, this is the don't, instead of just shutting down the media and saying no comment and I'm not interested and end of story, have a discussion with your client about the possibility of supplying background information. You can supply back, and I've done this in many, many complicated cases where you sit down and you provide a reporter with pleadings, with briefs. You go through the technical issues. You explain to them what your defenses are, what they're going to hear during the course of the trial, without ever being quoted, without ever attributing it to your client, so that you know that there's going to be TV coverage. And the least you can hope for is that they will accurately report on important testimony and important facts as they develop. And so I would say the don't is, don't just shut down the prospect of having any conversation. The do is talk to your client, and if you want to provide information on background, the start of a trial and throughout the trial, that is a very effective way to go make sure that at least there is the possibility that your story will be accurately told as the case is unfolding.
That's going on. A lot of people don't realize that you can do that. You won't be quoted directly, but it gives the reporter and the media outlet a sense of what the case is and the facts behind it. So great tip there. Thanks for that. All right. So now that we've talked about the do's and the don'ts, the lessons you've learned, about the Jenny Jones case, what was the end result in the Jenny Jones trial?
Yeah, well, there was a good news, bad news story there. The bad news was that there was a $25 million verdict awarded in favor of the Amateur family. Our motions for new trial were denied, and I continued to represent the client at the appellate level. We did the briefing, and I argued the case in the Court of Appeals. My opponent did the same, by the way. And the Court of Appeals, the Michigan Court of Appeals, in a 2-1 decision, vacated the verdict, said it had been improperly awarded, said that the case should never have gone to the jury in the first place, which was what the position was that we had taken both before trial, during trial, and prior to the time that it was submitted. So ultimately, the Court of Appeals agreed that a television producer could not foresee and had no duty to protect someone that was on their show who 4 days later was murdered by another guest on the show, 300 miles away. That was the bottom line, and that was what the Court of Appeals held. Michigan Supreme Court declined to review it. The United States Supreme Court declined to review it. So ultimately, the verdict, which was then worth, I think, about $33 million, was not paid, and the Amateur family, in this case, did not receive any financial recovery at all.
Gotcha. Right. Okay, any final tips you want to share for any of the attorneys out there who might also be dealing with something that's very high profile and very large, media intense litigation?
Well, if you don't mind me being facetious, I would say one tip is that if you do get involved in a high profile case, it's remarkable how the case follows you around for the rest of your career. And here I am 30 years later having a conversation with you about that case. People are always interested in it. This Netflix series has been entertaining. I've heard from a lot of people. It's remarkable to me how these cases, just the storyline of them and the interest level just never really seems to go away. And it brings some fun to the practice of law.
All right. Show on Netflix, Trial by Media. Make sure you check it out, everybody. Jim Feeney, partner with Dykema in Detroit. Thank you so much for your time today. I truly appreciate it.
Thank you, Kelly.
Thanks. Take care.